seconds to go. Start. On consideration of the authorities about the scope of sections 227 and 228 of the code, the following principles emerge, para. At the time of framing of the charges, the probative value of the material on record cannot be gone into, but before framing a charge, the court must apply its judicial mind on the material placed on record and must be satisfied that the commission of offence by the accused was possible. Para. At the stage of sections 227 and 228, the court is required to evaluate the material and documents on record with a view to find out if the facts emerging therefrom taken at their face value disclose the existence of all the ingredients constituting the alleged offence. For this limited purpose, sift the evidence as it cannot be expected even at that initial stage to accept all that the prosecution states as gospel truth, even if it is opposed to common sense or the broad probabilities of the case. Para. Summarizing the principles on discharge under section 227 of the CRPC, this court recapitulated para. At the stage of framing the charge in accordance with the principles which have been laid down by this court, what the court is expected to do is, it does not act as a mere post office. The court must indeed sift the material before it. The material to be sifted would be the material which is produced and relied upon by the prosecution. The sifting is not to be meticulous in the sense that the court dons the mantle of the trial judge hearing arguments after the entire evidence has been adduced after a full-fledged trial, and the question is not whether the prosecution has made out the case for the conviction of the accused. All that is required is, the court must be satisfied that with the materials available, a case is made out for the accused to stand trial. A strong suspicion suffices. However, a strong suspicion must be founded on some material. The material must be such as can be translated into evidence at the stage of trial. The strong suspicion cannot be the pure subjective satisfaction based on the moral notions of the judge that here is a case whether it is possible that the accused has committed the offence. Strong suspicion must be the suspicion which is premised on some material which commends itself to the court as sufficient to entertain the prima facie view that the accused has committed the offence. Para. Without getting into too many details, we consider it to be appropriate and in fact sufficient to confine our inquiry to three heads of expenditure indicated in the charge sheet itself. This limited inquiry will also satisfy the requirements of section 227 of the CRPC. Para. The first objection pertains to the inclusion and amount of rupees 55,000, recorded as the balance amount in the appellant's bank account during the check period, and accordingly counted as an expenditure in the charge sheet.